All right, so let's get started. Hi, everyone. My name is Bianca Petcu. I am an associate attorney here at Shipkevich, and as you can see, I'm going to be the moderator of today's discussion. So thank you for joining us today for this exciting conversation on the legal and regulatory issues that payment processors face in the debt settlement industry. We have a great conversation planned for you today between Sanj Goyle, CEO of Finxera, and our very own Felix Shipkevich, principal of Shipkevich PLLC. So let's just get right into it. Oh, let's see if I can change the slide. There we go. So today we are going to discuss and hopefully clarify the role that payment processors play in the debt settlement industry through this lens of regulatory and legal issues. So this particular conversation is going to be between an attorney who is very well versed in the space and a veteran CEO of a payment processor. So I think at least that it's going to be a great crossover of players within the space who can provide you with some great insight. So with that being said, let's turn it over to our panelists and let them introduce themselves.
Hi, everyone. Thanks, Bianca. I appreciate it very much. And I realize how much work it is to put on an event like this. So thanks to you and Felix for putting it on and having me on. And I would say that I'm particularly pleased because I think our industry could use more information share. It's this is a great step that you've taken to do in helping in that regard. And for everyone kind of dialing in, I hope everyone's keeping in good health and good spirits. It seems like Zoom is going to be with us way after COVID, probably. So let me introduce myself and a little bit about FinCEN. So I am Sanj Goyle, CEO and founder at FinCEN. I began my career as a corporate securities attorney, mostly in Silicon Valley. Took a couple of companies public, had technology clients, and then I went in-house to online marketing companies and really dealt with the privacy issues, the marketing claims issues, consumer protection issues in dealing with online marketing. And then for about 10 years, I moved to the business side. So for 10 years, I was actually running lead gen campaigns in the mortgage space. So I ran about a $35, $40 million P&L at a company called NextTag, at Interactive, then finally Yahoo. And then for the last 10 or 11 years, I founded FinCEN, a fintech business. And I've been running that for the last 10, 11 years. And we've grown the company to about 250 people. And what I think is one of the leaders in the debt settlement space.
Great. And Felix.
My name is Felix Shipkevich. I'm the principal of Shipkevich PLLC. I'll keep my introductions very short. In fact, before I do my introduction, I want to thank Sanj for being a co-panelist with me and for agreeing to do this. We've had this program in mind for quite some time and excited to finally get it done. I also want to thank my colleague, Bianca, who's been instrumental in helping us put this together. A little bit about me. I am a fintech and a regulatory attorney based in New York City. I've actually been in the fintech space and particularly working with money transmitters and payment processors. Oh boy, you'd like to say probably close to 2 decades. We're getting to the 20-year mark very shortly. I've been in the debt relief space as a regulatory attorney now for about half a decade, and I thought that there's quite a lot of interesting crossover between payments, money transmission, regulatory issues involving both the business community and the consumer side. And certainly there's quite a lot of interesting crossover between both federal and state regulatory environment. Outside of writing my practice, I enjoy teaching at Hofstra Law. I've been teaching there for a number of years, teaching corporate finance, and for the past few years teaching a course that is very close to my heart, which is the regulation of cryptocurrencies. The course is titled The Policy and Business of Cryptocurrencies, and with a very, very big focus on the payment side of cryptocurrencies. Anyway, thank you for joining us today.
Thank you, Felix. And a little bit about me. I am definitely newer to the game than Felix and Sanj are, but I personally have had the opportunity to work with both debt relief companies and payment processor companies. And I, again and again, see this crossover between the industries. So I definitely think that this would be a great conversation to have for a larger audience, like Sanj and Felix were both saying. So with that being said, let's get right into it. All right, so Felix, can you expand on what a payment processor does in this particular space? What is their function?
Sure. So the word payment processor is a very broad term, and it's widely interchangeably used depending on the type of industry you're working in. So for instance, in the debt relief space, payment processors, as Sanj will go into detail in a minute or two, the companies that accept funds on behalf of consumers and disperse those funds upon the settlement of those consumers, debt relief companies that they work with. But a payment processor has a very different meaning in, for instance, a payment space, right? The term processor, the word processor really is the imperative word here, which essentially means, as you could see on the first bullet point, it means a mediator, right? A processor is a technology mediator between a merchant and a consumer. And in fact, later in this presentation, you'll see a FinCEN definition of a payment processor, which if doesn't accept money and acts as a conduit, and there's a four-prong test. In fact, it doesn't have to register as a money transmitter. But depending on how the term payment processor is used, a lot of times people forget that processor could be someone that's performing a service as a mediator and perhaps is accepting funds on behalf of the clients. And therefore could be subject to certain money transmitter licensing requirements. And we'll obviously discuss that throughout the presentation. But for the purposes of this slide, I want you to understand the word processor as a mediator between two parties.
Great, yeah. And Sanj, could you actually tell us a little bit more about what FinXera does in this space and how it falls into this definition of a payment processor?
Yeah, you bet. And I think I actually have a slide later on. I think it's page 8, and I think it might be easier for people following at home to kind of take a look at that page. Sometimes I hear.
I can move forward. We can move to that slide, or we can get to that when we get to that. If you'd prefer to talk about it then, that's totally.
Well, I think that the way you teed it up, if I could for a second. So I think Felix is 100% right. Payment processor is kind of ill-defined. It's a generic term. The TSR, promulgated by the FTC 10 years ago, refers to us as dedicated account providers. State statutes, have various, references. But basically, what I think of is this. And for people who are just entering into the debt settlement space, it might be, illustrative. Basically, the payment processor, I think of providing three kind of things: a functional role, a regulatory role, and a consumer role. On the functional role, which I think we're focusing on now, is that the debt settlement program contemplates that a third party will hold the consumer's funds, and that the consumer will continue to contribute funds into, to the payment processor to hold for the consumer's benefit. And as that corpus grows, it can be used to negotiate settlements with creditors. And so the debt settlement companies, do a few things. They open up FDIC insured accounts on behalf of the consumer. They debit the consumer's regular checking account to bring funds into that FDIC insured account. The third thing is the FDIC insured account protects the consumer. So in my 11 years in the space, I think the use of the special purpose account that we maintain for consumers has really protected consumers from their funds being swept by creditors. And then the last, big bucket of work is managing creditor payments, which I always thought would be the kind of the simplest part, because everyone wants to make money, and creditors, when they collect money, would make it easy, but they really don't. So we put a lot of energy and technology and operations around making that as streamlined as possible for debt settlement companies.
Great. Yeah. And we definitely will get into that a bit more. You can go into more detail coming up on that. But for now, let's switch real quick over to what are escrow companies then? Because Felix, the definition of escrow companies and payment processors are often confused. And I know when I was first starting out, they were confusing to me too. So could you clarify what are the similarities and definitely differences between payment processors and escrow companies?
Absolutely. There's definitely some overlap, and which essentially causes confusion, particularly in the debt relief space, because a lot of times I hear, whether at industry conferences or when just speaking to individuals in the space, when they refer to companies that provide services for and on behalf of the consumers, they refer to escrow companies, right? Why? Because look, the consumer deposits money on a monthly basis, and that money accumulates. And a lot of times, instead of using the word payment processor, they use the word escrow. And part of the reason why I put this slide in is to actually legally distinguish the definition of escrow, an escrow agent versus a payment processor, right? A definition of an escrow company, right, is someone that provides a fiduciary responsibility on behalf of someone else, a depositor, right? Essentially, it's an escrow company is a company that acts as an agent. We certainly have escrow companies that, in fact, are licensed as escrow companies, for instance, and I'll talk about this in about a minute, next slide, but limited trust charter companies are pretty big these days, particularly in the cryptocurrency space. You have attorneys that offer, trust services for funds that belong to their clients. Banks provide trust company services, escrow services. The reason I wanted to point it out in this presentation is that a lot of times legally the word escrow is intertwined, and it's technically not legally correctly intertwined with the services that are provided by payment processors, right? Just merely because a balance accumulates, it doesn't necessarily mean it's an escrow. And that's probably one of the biggest misunderstandings in this space.
Yeah, no, definitely. And you were kind of getting into that, but could you provide an example or two of an industry that what actually uses an escrow company, or it could be considered an escrow company?
Yeah, absolutely. My favorite example is attorneys. We obviously know that there are a lot of attorneys that provide debt relief services in this space, right? And attorneys have generally two types of accounts, right? They have their operating accounts, right, to run their business, to run their practice. And then they have regulated trust accounts. And depending on the state, these trust accounts actually have different names or acronyms. In the state of New York, it's IOLA. In other states, it's called IOLTA. And believe it or not, the rules, the professional responsibility rules that govern these trust or escrow accounts for attorneys are quite significant, and they vary from state to state. And believe it or not, having been licensed, in numerous states in this country, I can tell you that sometimes they vary. But the general consensus is, why do attorneys have escrow accounts, right? That act as escrow agents on behalf of their clients, is because by law they're carved out the ability to provide escrow services and hold funds that do not belong to attorneys. In fact, under almost every state professional responsibility rules, you cannot commingle your earned fees with the funds that are that of your clients. You can get into some serious trouble. And in fact, there are plenty of cases in almost every single state where attorneys commingle those funds and don't reconcile them, and therefore could actually lose their license. So one of my favorite examples is attorneys, and we need to be mindful, particularly when the funds are coming in for the purpose of accumulating funds to be paid out to creditors. If you're a debt settlement company, you work with companies like FinCEN, right, where you accumulate and they have the proper licensing. Or if you're an attorney, you probably may want to accumulate this in your IOLA account. Why? Because the money is actually being accumulated for the purpose of being paid out to third parties. So that's kind of the example in here.
Yeah, great. And now we can actually, sorry, yep, Sanj, were you gonna?
Yeah, I thought maybe if I could kind of riff a little bit on what you were saying there, Felix, because I think for the listeners at home, I think helping you understand how the regulatory schema fits. And colloquially, we'll call the service that we provide payment processing. I oftentimes call it escrow and payments. So it's natural that you think that the work of a payment processor is what would be typically licensed as an escrow service or an escrow company. And we actually have spent a fair amount of time looking at that over the last decade. We're FinCEra. We take the view that the work of a payment processor for debt settlement is broader than what the typical concept of an escrow service is. So escrow contemplates that you will hold funds for a specific purpose with set rules, and then when those rules are met, you'll disperse the funds on behalf of the beneficiaries of the escrow. That's the traditional sense of escrow. Now, when you think about what we're doing in the debt settlement context, we are creating really a special purpose account that's a unit of stored value for the consumer, that the disbursements of those from those accounts is not set, where it is really a facts and circumstances as the consumer saves money, gets into settlements. There may be a lump sum settlement or installment. So it doesn't have, what we do, part of the work is escrow, but the attributes of how we do it make it very different than the licensing regime that has been set up in various states for escrow services, as opposed to the broader service, which is money transmission, which includes not only the holding of consumer funds, but also the instructions that can change over how those are distributed out, and the charging of fees to the consumer. And the one thing and we actually have, we're licensed in nearly all 50 states, certainly every state that debt settlement operates in. And we have asked the question to state banking departments. And we've gotten a very kind of, I would say, disappointing or, answer that the escrow statutes were really not designed for the work we do as a payment processor in debt settlement. And kind of the benchmark of what they've indicated to me, and as I've personally talked to them, is that if you apply the escrow statutes to the work of debt settlement, that you would kind of eviscerate most of the regulatory schema around money movement, because that means you could use an escrow license to manage gift cards, to do debit cards, and that's clearly not what was intended. So whereas I agree, wholeheartedly with what Felix was saying, part of what we do is holding funds in escrow for consumers, but given the broader set of services that we provide, we think that's licensable activity as a money transmitter.
Yeah, and that's excellent insight. Thank you for that. And now we can actually circle back to what you were talking about before, and the role more specifically on what payment processors do in the debt settlement industry. And I know you already briefly went over these, so we can move on to the more specific things that you wanted.
Well, actually, if you can, Bianca, let's go back to page 9, because I think there's some things I'll augment on this. So just as a, and I think for most people in the industry, you kind of already have a feel for it on the functional side. It's the opening up of an FDIC insured account, which is very important, particularly as we have so much turmoil with banks these days. FDIC insured account that protects the consumer's funds from creditors sweeping their assets when they are delinquent, and bringing funds in, auto debiting the consumer's DDA. Although we do take checks as well, and we deposit them same day. Even through COVID, we've been able to manage that so that we can fund that account. And then the third part is managing the payments out to creditors. So in a broad sense, those are the three components of what I would say is the functional work of a payment processor in debt settlement. There's a second piece, which is this regulatory one. And here's where I think, particularly if you're just getting into this industry or have been in it for a while, both at the federal and state level, the regulatory schema that governs debt settlement contemplates that a third party will control the funds of the consumer. So if you look at the TSR, it speaks about a dedicated account provider being used to help the consumer move through a debt settlement program. In state, in the state statutes, in my home state of California here, there's a prorater law. And so the prorater law has fee caps, it has restrictions. But one of the big exemptions from the prorater laws is If you do not control the funds, then you're not subject to being a prorater. And statutes change over time, and every state, has some kind of variant of that. But so that's why using the third party payment processor to hold funds, move consumers' money, is a way to be in compliance with the federal and state rules, and also get out of some of the more onerous prorater rules that I think are now. There's a lot of action going on in the industry about changes in state laws, but as it stands now, in California anyway, large state for debt settlement, the prorater laws are still in effect. And if I could say, I think that it's just from our perspective, we're very bullish about the future. We think our industry is going to have a big role to play as as America gets into a post-COVID world. And so, we also think that the success of the industry that's coming will invite some regulatory scrutiny. And it's good to, it's a good timing right now to kind of brush up on all these, different requirements. The third aspect is, I'd say, is a consumer-focused one. And this is something when I communicate with the compliance departments of the multiple banks we work with, and all the 48 the banking departments, state banking departments, is that we believe the payment processor has a role as an advocate for the industry by acting as an internal auditor in the space. And so what I mean by that is, as we all are aware, there's the performance model, there's the kind of the advanced fee ban, for lack of a better word, that came out in 2010 in the TSR. And in the TSR, it contemplates that a debt settlement company won't charge a fee to a consumer until they've negotiated a settlement on behalf of that consumer and the first payment is made. And one thing that we see is we are able to put controls in place and monitoring to make sure that all the fees collected comply with the TSR. So that way, if there's ever an issue where you have to demonstrate compliance, we do that as a matter of course, so that we can create the reports and backup necessary to demonstrate that. And so not only is that a good thing in terms of advocating for debt settlement companies before regulators or any kind of investigation, but it's also a good backup for a consumer that knows that their funds are being held properly. And then the second thing is about the consumer aspect of it. Is I think there was a study. It's quite a number of years ago, but it came to the conclusion that working with a third party payment processor for holding funds in a kind of set it and forget it. So if a consumer on average is, let's say, contributing $300-400 a month into the program, that by doing so in an automated way, and the funds being held segregated from the consumer's other accounts, had an 80% better chance of the consumer actually completing a settlement, which I think is an important factor. They have to think that, ultimately, the way we think of our special purpose account, in many ways, it's a virtual bank account with all the features, but we disable the ability to access it, via check writing and other things, because the purpose of it is really to save money that can be used for settlement. And I think having this kind of third-party automated process is really helpful to the consumer as they progress along the debt settlement program.
Yeah, and that was actually answering, I guess, a question that I had for you was, what does a payment processor offer that a simple account at a bank does not? And I think you explained that pretty well on why it would be good to set it and forget it, like you're saying.
Yeah, and also keep in mind, like if a consumer opens up an account in their name, that account is attachable by their creditors fairly quickly. So in our experience, sometimes we get served with notices for bankruptcy or something like that. But we've never really had the case where a creditor would try to attach funds held in debt settlement, a special purpose account for debt settlement.
Yeah. So I think there are some other things that you wanted to consider or people to consider when they're thinking about your company and also just what payment processors offer in general, if you'd still like to elaborate on that.
Yeah, sure. And so, for people tuning in, you're fortunate that I think we're in an industry that does a lot of consumer good. It's poised for a lot of growth. So it's a right time to think about how you want to be a player in the space, how you want to be ready for the scale, how you continue to keep your market share, and really build what I believe should be a sustainable business over the long term. I mean, and so I'd give you a few things to consider. The first being bank partners. So at FinCEra, and I'll speak to our situation, we have 6, soon to add a 7th different bank. We have Wells Fargo, and we call them processing banks because even though we are a licensed money transmitter, so we are a regulated custodian of consumer funds. So we can hold those funds in our own name for the benefit of the consumer. And we think that's an important compliance step and protection step. But we're not a bank. And so what we do is we open up accounts at different banks, and we call them processing banks because we use those the banks to not only deposit the funds, but they are the ones who set up the auto debiting of a consumer's DDA and managing some of the payments out to creditors. So we work with Wells Fargo, Comerica Bank, Axos Bank, Texas Capital Bank, Metro Bank. And when we go and work with a bank, we give them a 10-page PowerPoint that says, operationally, this is what we need from you, because after 10 years in the space, we know some of the issues that a debt settlement company will face. For example, do you need to have ACHs processed over the weekend? Will you allow us to revoke a payment made to a creditor more than 30 days out, which is an important part of the negotiation process? And so we come up with a laundry list of things. And so having good bank partners that allow you the flexibility you need to run your business is very important. The second thing, which is I also think that diversity and redundancy is extremely important. So I've been in the space long enough to know that we've already had 2 banks that processed in the space that dropped out. Years ago, more than 10 years ago, Rocky Mountain Bank, and then we worked with a bank called Four Oaks Bank. They processed in the debt settlement space, and then they got out. And I vowed that I would never have a risk profile like that. So I think for example, if things change from a regulatory event or something internally to a bank, and they decide that they don't want to be in what the FDIC still considers, I think wrongly, but it still considers it a high risk area, then our feeling is being able to kind of switch your processing and deposits over to another bank seamlessly is going to be very important as part of scaling a business. We, as a technology company, we're Silicon Valley based. Me and my partners were technologists and marketing people over at Yahoo. We've invested and created what we like to think is an overlay on top of banking, so that the accounts that we manage, we're the system of record, and funds can be held at any one of those 6 or 7 banks. So literally in real time, if we can't process with one bank, let's say there's some technical problem or an environmental issue, where there's a hurricane or tornado, we can seamlessly move to another bank. So anyway, that's one big consideration I think you should use in considering which payment processor. And the second is, I would say, the regulatory approach. And reasonable people can differ, but after a lot of discussions with our lawyers and talking to banking departments, we take the view that the Federal Trade Commission's TSR is really the rule, the law of the land, and the performance-based model is really what the government contemplates debt settlement companies do. And so we have a lot of rules and underwriting around that. Obviously, reasonable people can differ, but we take that view, and we think that that approach, if you follow that approach about a performance model, that there's a stronger argument for if there was ever an investigation of your service, that at least we're following the rules. And also, we've come to the view that payment processing for debt settlement, if you think about those constituent services of opening up an account, holding money in that account as an item of stored value, pulling in funds from the consumer and sending them out to creditors, we take the view that that's licensable activity as a money transmitter. So we're one of, I believe, 25, 30 companies that are actually licensed nationwide to perform that role. And so, I think that's an important consideration when you think about, hey, your business, and if you think about all the risks you take, it's sometimes, I think about any successful business, you want to de-risk it, right? You want the reward when there is reward, and if you're not getting a reward, de-risk it. So that's one way to de-risk things, I think, is thinking about those compliance issues. The third thing I would think about also is the product roadmap. And this may be a little counterintuitive, but let me explain what I mean by that. Is that I think in many ways, the payments, the escrow and the payments is fairly straightforward. You kind of think, hey, it just, it works. There's not a lot of other things that you might need with that. But what I have found in my years in technology and marketing and now banking is that your business will always change, and that you need to work with a partner that is going to allow you the flexibility to change as you need to do so. For example, you may want to start a lending program, or a debt consolidation, loan. You need the flexibility to offer that seamlessly in your, in your funds flow. Or, one of the biggest issues that settlement companies face is the retention. We all know that this is a high churn business. So client engagement is a really important factor. So a couple of things that we've been doing on the roadmap is we've rolled out an integration with a company called Early Warning Systems, as well as a company called GIACT. And what they allow us to do is, before you debit a consumer, to validate that the account is actually a valid account. And so that rather than allowing the draft to NSF or get a return, we're able to tell you in advance, hey, there's that account number doesn't work. So, maybe it got fat fingered, or there's a wrong digit or something like that. And so you can contact the consumer, get the accurate information, and then the debit will go through. And again, that helps with keeping people in the program. The second thing is, we've noticed that there's a big correlation between a consumer's ability to make the first debit, that first draft. The success of that has an outsized role in the consumer staying committed to the program, and them succeeding, and the debt settlement company succeeding. So what we've started doing our roadmap is, we now have the ability to allow a debt settlement company to collect the first draft via a debit card over the phone. So one of your agents, when they're talking to a consumer, can take a debit card number over the phone, and we can process that in real time, so that the consumer, and by the way, a debit card is good funds immediately. There's no return capability there. So that way, that they're committed, they made their first draft. Now, it is more expensive, so it's something we think doing the first debit is probably sufficient, but it could be used in the future if there was a use case. So that those two things. And then the third, I would say, is analytics, reporting, and business intelligence. And we maintain about 3 business intelligence staff headed by a director level person. And we also have optimized for the Looker visualization service that Google bought. And let me explain what I mean by that. So we take a look at all of the data that we're collecting, the debits that we do, the balances, the payments, all of that data, we snapshot outside of our production database into a database that we only use for analytics. And then we have a data warehouse and a visualization layer on top of that. So that way we can run customized reports. So if you wanted to know, what was my retention this month as opposed to 6 months ago? What happened on first debits? and a failed first debit, what was the impact of that down the road? We have a lot of that analytics capability that we run as a matter of course, and we can also create customized reports. In fact, some of even our largest customers, and we have small customers and large customers, they're using us to provide them feedback as to how much fees they've collected, the churn rates and all that. And that's something that I think, as you prepare for a period of what we hope will be quite a bit of growth, that insight into your business is something that you can look to a payment processor to help you with. So the fourth area is what I would call these value add services. So, in any business, you'd like to think, hey, you can do the same thing forever and it'll always be the case. And, you stay in your in your box. And what we have seen is that, we have quite a bit of assets that we think can be leveraged by debt settlement companies to further their business. And the first one is we have a business process outsourcing service. So we're maintaining now about 50 different full-time equivalents where we're doing back office work for our debt settlement companies, payment operations like phoning in a check payment, validating the compliance on a graduation. There's a bunch of things that we have a very low cost infrastructure and technology set, the way we've built the business. And we're allowing debt settlement companies to kind of offload some of that expense and mind share that they would spend on the back office, so they can focus on where they are really good, which is the customer acquisition and the creditor management. So that BPO is something that can be of value to you. And then the last thing on the value add services is, we take a very technology and product focus in the way we approach payment processing for debt settlement. And so we're just launched a mobile app that's a white label mobile app that any debt settlement company can skin and brand for their use. It's available in Apple iOS App Store as well as Google Play, and you can download it and you can see see how it functions. And we can be happy to give anyone a demo on it. But the whole concept there is, let us leverage technology that we're good at to help a debt settlement company better manage their consumers, the engagement, and reduce churn. So these are the kinds of things that, when you look about the growth that we hope is going to happen in the industry, that these things are important for your business, and you can start to expand your view of what a payment processor can do for you.
Wow, great. And actually, there's something that Sanj mentioned briefly a bit that, Felix, I would like you to kind of get into a bit more. This idea of being a money transmitter. So here are just 4 of the largest regulators in the US that deal with money transmitter licensing and regulating. So Felix, are payment processors really money transmitters, and should we be concerned that they're subject to these money transmission laws? And what should you be concerned about as a payment processor in this space?
So the short answer is yes. The payment processors in the debt relief space, debt settlement space, are generally viewed to be money transmitters. Not in every state, but in most states. And if you are looking to provide these services, you obviously have to do your own survey on state-by-state basis. But I can tell you that the general rule is as follows, and it's pretty easy to follow. If you are receiving third-party funds for disbursement to someone else, you are essentially performing money transmission. And that's the type of service that the states regulate, right? As a non-banking license. A bank doesn't have to be a money transmitter, but if you are receiving, right? So if I'm sending money to Sanj, but I send that money first to Bianca, and Bianca takes that money and sends it to Sanj, Bianca performed money transmission, right? It's the concept of receiving the money, which a lot of times for the purpose of transmission, what really triggers money transmission, right? So again, I can't speak for all of the participants in this space, but if you are a participant in this space and you are receiving money from a debt settlement clients for the purposes of accumulating that balance, and at some point the debt settlement client, whether directly or vis-a-vis the relationship with the debt relief company, says, I'd like to pay creditor X the following amount of money because that account was settled. You now take money that doesn't belong to you, right? That you've accumulated, and you send it per those instructions to someone else, right? So let's go to the next slide. It's just to give you a quick example.
Yeah.
So a big state, California, right? California, and Bianca, you'll talk about the legislative proposals or changes that, really what's happening in California. Big state on radar for 2020. But what's interesting is that, the money transmitter statute is very, very simple, right? Very simple. In fact, California is the simplest money transmission definition out of anywhere else in the country. And I'll give you an example for Florida and Texas and New York in about a minute, right? But you say it says money transmission means one of the following, right? Selling or issuing payment instruments, right? No, but the payment processors in this space, in the debt relief space, they do not sell you, issue payments, at least not that I've seen, right? Are they selling or issuing stored value? Well, you're not really selling stored value. Stored value generally means like gift cards. And obviously there's a big distinction versus gift cards that are within a closed loop system, an open loop system. Obviously this is not a webinar on the subject matter of closed and open loop system. And Bianca and I will actually do that in 2 weeks if you're really interested in learning the difference between the two. It's the third prong, receiving money for transmission. Receiving money for transmission, right? So if you're a payment processor and you are providing services to debt settlement clients, and those debt settlement clients, right, they open accounts with you. They don't open accounts with their underlying bank. They open accounts directly with you, right? The relationship documentation is between a client and the payment processor, not a client and the bank where the account is held by the payment processor, right? Essentially becomes like a ledger entry or a sub account. But the bottom line is the money is received for transmission. Let's move on to the next state. So I can show you an example, right? Here's New York. As you can see, New York makes things a lot more complicated, right? But actually, we've bolded some things for you to make it very, very simple, right? Again, no person shall engage in the business of selling or issuing checks. You already seen that. In the business of receiving money for transmission. Again, the same language, right? So let's move on to the next state. Florida. Money transmitter means a corporation, limited liability company, and so on, receives currency, monetary value, or payment instruments for the purpose of transmitting the same by any means, for the purpose of transmitting the same. Now, the question that, companies in the space always ask me, well, I'm not really transmitting, I'm not transmitting it now, I'll transmit it in the future. But if the purpose is of you're providing that accumulation for the purpose eventually to send it to creditors, it's kind of a closed case. I mean, I don't know how you could stretch the law. It really says what it says. Let's move on to the next state. Texas, big state in this space, right? Money transmission means the receipt of money. And again, I emphasize and I highlight the term receipt of money, right? And then in exchange for promise to make monetary value available at a later time or different location. That's what it means. It means that if you're in the process of receiving money, then you should be for the purpose of sending it to creditors in the future. Now, I'll give you a few examples. Obviously, each state has its own exemptions or exceptions to the licensing requirement. And those exceptions or exemptions vary from state to state. For instance, I've dealt extensively over the years with Texas Department of Banking. They have about 14 exemptions. The state of Florida has 3. Now, the question is, wait, so if Texas has 14, maybe we could fall one of the exemptions. And the fact that Florida has 3, well, that's not so good. It really comes down to a few things. You can't just look at the plain statutory exemptions or exceptions to the law. You have to look at the previously issued guidance. Now, there are some states that don't intend to regulate this type of activity, even though it may fall within the 4 corners of money transmission. Now, wait a second. You're going to say, hold on a second. You just told us in the past few minutes that if you're in the business of receiving money for dispersing it to third parties, then you have to be a money transmitter. The short of it is that interpretation, even though on statutory basis, is pretty much consistent across all 50 states. There's some states that may not want to regulate. There are very few states like that, but again, that's a more comprehensive discussion, based on what your model is. But generally is, unless you fall under the exemption, unless the state issues any type of no action relief or has previously issued any type of opinion on the record, any guidance to say, well, we don't intend to regulate these type of businesses, you should probably assume what I said at the very beginning, answering Bianca's question, is yes, you are providing money transmission services. Let's go on to the next slide.
And to kind of add to that, there's the federal side of it as well that Sanj was discussing with the TSR. So Felix, can you talk about more of the background of TSR rule and tell us exactly what payment processors should be aware of and what are the key issues with TSR?
Absolutely. So for those of you who are not in the debt settlement space, you probably may not have heard of TSR, or if you've heard of it, you probably don't know much about it as much as debt companies in the debt settlement space do, and the debt relief space do. I shouldn't probably just include debt settlement companies, because you have to be mindful that TSR applies to lenders, it applies to other companies in the space. The rule has been around for over 20 years and was amended in 2010. And I think Bianca and I have done a pretty comprehensive webinar a few months ago on the application of telemarketing sales rule, TSR, in the debt relief space. And you could find the recording of that webinar on our firm's website. You can go to debtreliefwatch.com, which is an affiliate site of our firm, and pull that recording if you're interested to know more. But what's interesting is the telemarketing sales rule specifically addresses the regulation of payment processors in the space. And what you have essentially are 5 prongs, 5 requirements under the telemarketing sales rules as it applies to customer funds accumulation, right? The first one is easy. It has to be at a financial institution. It's pretty self-explanatory. The second is customer owns the funds, the account, right? Meaning that, the government, federal government says, look, it's not your funds, it's the customer funds, right? It's not your funds, it belongs to the customer. Obviously, very important customer protection point. 3, the entity administering the account is not owned, controlled, or in any way affiliated with a debt relief service. Here, this is a very interesting prong, because essentially here, the law says, look, we just want to make sure that there's no potential conflict between the company that's administering the account, in this case, for the purposes of this discussion, is a payment processor, and the debt relief company. It wants it to be, completely not owned, controlled, or affiliated. The term affiliated is really loosely used, because, and I think they could have done a little bit better job saying the word affiliate, because that's probably a different webinar, different discussion. D, the entity administering the account does not give or accept money or the compensation exchange for referrals of business involving debt relief service. Very important, right? Basically, TSR says you can't get any type of incentive for getting referrals to your payment processor. Again, it wants it to be completely neutral. And the last one, customer may withdraw a fund at any time without penalty, essentially says, look, if just like we said in the second prong, the customer control the funds, the customer could also withdraw the money at any time at their request. So I think that's a very important part of the TSR.
Yeah. And Sanj, is there anything here that you'd like to add about TSR, just like as a CEO of a payment processor, that you consider when you're running your business? I know you already mentioned a bit of it, but.
Yeah, I mean, I look at it this way. The threshold question we always ask is, what is the risk profile of the companies we work with? Do they believe in this, in the performance model? And if they do, what we try to do is be an advocate for them to make the compliance as easy as possible, and that with push of a button, we can create all the backup in the reports that said, you followed this TSR, that you didn't collect a fee until a settlement was reached, the first payment was made, and then your fee was actually pro rata based on the debt that was settled. So I think these are kind of important things about, they put some operational and capital requirements on the business, but we do our best to try to make it easy to comply.
Yeah, that's great. And then sticking with this federal law considerations, there's the FinCEN guidance that Felix had mentioned earlier, and the conditions that are sent out by FinCEN for an entity to be designated as a payment processor. So Felix, per our conversation earlier, we explained that a payment processor should do serious analysis and get money transmitter licenses where applicable. Why shouldn't they simply just follow this FinCEN guidance and not register as a money transmitter because of the FinCEN conditions?
So it's a great question. FinCEN is not a regulator. It's an enforcer, right? It's an agency that oversees financial transactions, and particularly for the purpose of preventing any financial crimes. It's hence why it's Financial Crimes Enforcement Network, right? Any type of potential money laundering that could occur. FinCEN is not a regulator. That regulator, in fact, the license itself to do that type of business is actually on the state level, and that's probably one of the biggest misconceptions. We have many clients that come from overseas that get into the payment space, and they're, we'll get the FinCEN MSB license. Well, no, that's not so simple. It's just a registration. That's really what it is. But what's interesting is what I said earlier in this presentation is that, from the FinCEN point of view, and there's, again, if you're very interested, I'm happy to send you the FinCEN payment processor guidance. FinCEN carved out payment processors in its own category, and that's why I said earlier that the term payment processor in the debt settlement space is very different than a payment processors in other payments or payments related, like crypto spaces, right? The areas. Payment processors really viewed as technology companies, and these are the four prongs that you see on your screen that are specifically directed by FinCEN to be qualified as a payment processor and not required to be registered and as a money service business or money transmitter.
Yeah, if I could add, the federal government has these rules that they take a view of notify us so we can potentially monitor you. And they do this in the context for some of you who have foreign bank accounts. So there's a rule called FBAR, where if you own a foreign bank account that has more than $10,000, you need to notify the federal government. Not that you have to pay any additional taxes or anything, you just have to notify them. So that way, in the back end, they can subpoena banks and whatever, if they choose to kind of see, hey, are you getting a lot of money there, and did you pay taxes? Similarly, with this FinCEN, it's basically a notification to the feds. And as Felix said, it's the Financial Crimes Enforcement Network is what it stands for. But it gets kind of roped up into a lot of different things. So one of the things that maybe not well understood is that if I could digress a bit, this may be interesting. If I don't know how many of you play, poker or gamble and do so online. It used to be a thriving industry, probably still is. And the government really couldn't enforce its rules against like online poker, because you could set up a server in Antigua and whatnot, and people could thwart it. But what they ended up doing is they essentially deputized the banks and said, okay, since we can't control this business on the internet, eventually funds from a US consumer have to be taken out of their bank account or their credit card account. And if a bank allows that transaction without having done the diligence to make sure that it's not being used for an illicit purpose, the bank is on the hook. And that's what this FinCEN is all about. So which tells us that that type of a ethos is what, like, the TSR and the CFPB and maybe the California's new, more empowered Department of Business Oversight will start to do. They'll look at payment processors to say, hey, you're in the funds flow. We can't really control how online marketing is done or display advertising, radio advertising, but we can focus on where the consumer funds are being collected. And so that's why we make a big effort to explain, or first of all, we make a big effort to understand what the rules are,
develop processes and products to kind of comply with it, and then communicate that, to our customers and try to make it as easy as possible. So that's kind of my view of this, FinCEN.
Yeah, and just considering all of what we just talked about, regulatory wise, statutory wise, perhaps it is the attorney in me, but enforcement actions and the lessons learned from them tends to be what I find the most interesting. So here I just collected the biggest, broadest takeaways from a few of the main cases and biggest like federal enforcement actions against payment processors in this industry. And as you can see, most of them are directly related to the TSR. So a lot of the things that Sanj was talking about and Felix was talking about on the TSR slide are things that you definitely need to consider. Payment processors are responsible for knowing their customers and their customers' business, meaning the customer here, meaning also the person who puts the funds into the payment processing system, but the debt settlement company that they're working with. Payment processor companies could also be added as co-defendants in an action against a debt settlement company. And that's often what we see. A debt settlement company will be sued for something. And then a few months later, a year later, the payment processor is also brought into the same case. So you cannot simply avoid the TSR because you are a payment processing company and not a debt settlement company, which I think we've kind of hit the nail on the head a few times on that one. But many of these enforcement actions do involve payment processors that turn a blind eye to TSR infractions, especially in any form of upfront fees and outright ignoring the TSR's advance fee ban. And payment processors can also be brought into actions on engaging directly in unfair acts or practices and providing substantial assistance to the debt settlement company's unfair or deceptive conduct. So it's definitely about knowing who you're playing with in this industry as well, and to keep that in mind on the enforcement side. And also quickly, Felix mentioned this earlier, but there is legislative updates in California that deal with payment processors. This honestly has stalled quite a bit from when it was first introduced. So there isn't much to update you on that you haven't seen already on Debt Relief Watch that we've been tracking for a while. But Sanj and Felix, do you have any concerns about this particular legislative update or anything else that has to be considered here where it would make payment processors automatically vicariously liable to the actions that they're doing with debt settlement companies?
Well, yeah, thanks for asking the question, Bianca. My view is I look at this not in isolation, but kind of against the backdrop. So what you have in my home state of California, and by the way, I'm active in some of the efforts going on amongst the California legislators, is that California has, I think we've mentioned, is beefing up the enforcement powers of the Department of Business Oversight to kind of act like a mini CFPB at the California level. And so what I feel is this statute will get kicked around and may or may not see the light of day, but in the context of the broader powers that the California DBO has. And I think that, what it's going to be incumbent upon everyone in the industry to show is the consumer benefit that that there is from participating in debt settlement for the consumer, and that across the supply chain, from the affiliate and the in-house marketing that's done, the way disclosures are done to a consumer, all the way through is your payment processor compliant. All of that is going to be taken into consideration by the DBO. So I don't fear this statute in particular. I mean, because it's not the law now, but I do think that we all have to kind of be prepared for kind of the fight that's going on in California right now, which is going to kick off in after the new year, and my hope would be that the debt settlement because and this is just my view of it, it may not be the case, because the statute that changed in California was so broad to make the DBO more like a mini CFPB, that it's conceivable that they will have bigger fish to fry. They may go after bank overdraft fees. They may go after payday loans. They may go after a whole suite of services first before they start to think of a debt settlement. Again, we'll see, but there may be a silver lining in the breadth of the new statute.
Yeah, and we do on Debt Relief Watch, I think it is, or moneytransmitterlaw.com, have an article talking about the mini CFPB and how DBOs changed their name to DFPI and all of that. So if any of the participants want to learn more about that, you can go to our website and look into that a bit more. So this is wrapping it up, but hopefully you all learned quite a lot about the interwovenness between payment processors and the debt settlement industry, and even with money transmitters. So Felix and Sanj, is there one main takeaway that you hope our listeners get from this robust conversation today? What would be the one thing that you would really hope people would take away from this?
Felix, you first.
Sure. From my point of view, I think that if you're a debt settlement company or you're looking to get into the space, you need to make sure you find the right partner in the payment processing space for so many reasons, as obviously both Sanj and I discussed in the past hour. This partner will be your partner not just from the commercial, but very important and unfortunately often ignored legal and regulatory side. You need to make sure that the company that you select has the proper licensing, has the proper legal and regulatory infrastructure in place.
Felix, I would echo exactly that. I mean, I think we're fortunate that, in this industry, you've got some good choices. In many ways, you are as good as the company that you keep, both from affiliates and your payment processors and your external lawyers. And I think if hopefully, I'd be happy to, share the slides I prepared or have any follow-up conversations. But I think that the takeaway would be just take a look at those few dimensions on how to evaluate your partners and come to a choice that you think is the best for your company.
Great. Yeah, so thank you both very much for joining us. And like we mentioned, Felix and I mentioned, there is debtreliefwatch.com and moneytransmitterlaw.com where you can see more articles on both of these things, keep abreast of the news that's happening, regulatory changes. So yeah, that's our contact information, but thank you so much for joining us today. And thank you, Sanj, for joining Felix and I on this conversation.
Yeah, and thank you so
Sanj,
much for what you've done for the industry and having these kind of forums. Thank you again.
Thank you everyone for joining us.
Thank you.
Bye-bye.